Howdy. Apologize for my voice. We're going to work on Chapter 2. All right, now I'm going to split this into 4 videos, and this isn't in your book, but I want you to understand the process of different things in a lawsuit, how it's filed, different ways laws are enacted. Keep learning about different causes of action, state common law, statutes, and the like. So let's just talk about this, and this isn't the book. Let's say we're filing a civil lawsuit. Now, a civil lawsuit is a person versus a person, or a person versus an entity, or an entity versus a person, or an entity versus an entity. Criminal is always government versus an individual. So in a civil lawsuit, I'm going to sue somebody. So I'm the plaintiff, and I'm going to file a complaint. And when I file a complaint, I'm going to serve a copy of that complaint to the defendant with what's called process. And process means just that. You get a process server, you pay a professional to do it, because this is a very important step. The defendant must be properly served with notification that it has a complaint. And if you fail this step, just the rest of the lawsuit is no good, okay? So you have to have a cause of action that's recognized in your jurisdiction, either by a statute or common law. So for instance, I can't say, I don't like blue flags, my neighbor's flying a blue flag, I'm going to sue my neighbor for flying a blue flag because there's nothing on statute or common law that makes that a cause of action. Once the service is executed, the defendant must respond to the court within a specific time frame. And this is typically in Texas, you just do a general denial. Somebody's going to file a complaint, they're going to allege 4 or 5 things. You might say, yeah, one's true, but the rest are false. No, you just say, well, I generally deny all of them. Sometimes when this is done, the defendant will file a motion to dismiss, point to the plaintiff's pleading the complaint, say it's not adequate, and very rarely does this happen, but the judge must accept all facts pleaded by the plaintiff as true. So if you have a well-written pleading, typically the judge fails to grant a motion to dismiss. Then both parties move to discovery. And discovery is where I give you a list of documents you need to provide to me, and you give a list to me. And in the old days, this was pretty easy. You went to the file cabinet, and you went to your copier and copied it. Now in the electronic age, I might ask for all emails that you have relating to a certain subject, expecting maybe 500, and it'll be 50,000 or something. You have very strict time deadlines, and you have to provide all the information in discovery within those deadlines, or risk sanctions. And sometimes sanctions can be, if I can prove that you should have provided a document and you claim the document doesn't exist, but I give some pretty good evidence, sometimes you can get evidence deemed as being admitted, like one party is intentionally not providing it. Now at this point, each party, or either party, may file a motion for summary judgment, alleging that the other party has not demonstrated its case. Always you file a motion for summary judgment. Always, always, always. And if the defendant files it and the motion for summary judgment and the judge grants it, the case ends. The plaintiff will file it, typically, even if the judge thinks it's a good motion for summary judgment, the judge won't grant it because he's accepting all pleadings, facts. And don't confuse this with a default judgment. If you fail to respond to the court with a general denial and never show up, that plaintiff can go and get a default judgment against you. And depending on the time length you hold it on, your recourse for having it thrown out becomes more limited. So within 30 days, you can get some remedies. Within, I think it's 6 months in Texas. After 2 years, unless you can prove you were not properly served, even though you might be extremely innocent of everything that was in that pleading, you'll be held accountable. So most cases don't go to court because juries are a risk, and most settle out of court. But otherwise, you proceed to court, and then you begin to follow a whole bunch of rules. Now, if you're in federal court, use the Federal Rules of Civil Procedure, FRCP, sometimes you'll see it. If you're in, and this is just a picture, and you can go there if you want. Rather, I want to show you the state court. And if you go to the state court here, you'll find the rules of civil procedure, the appellate procedure, that's a review procedure, rules of evidence, statewide rules on electronic filings, etc., etc., etc. Let's look at a few things. So, first of all, you'll notice this was just updated January 1st of 2018. So they keep these updated, and it's evidence how you can have privileges, attorney-client privilege and the like, witnesses, opinions, hearsay, definitions that apply to this, exclusions, the rule against hearsay, authentication and identifying, which is not authentication and identification in our electronic sense. So then we can, let's see, what's a good one to click on? Let's go to hearsay, the rule against hearsay. So here's the rule. It's not admissible unless any of the following are true. If it's not admissible, unless it's by statute, rules, or other rules. And then it starts the exceptions to the rule against hearsay. So typically it's inadmissible, and in court, the lawyer's going to make a exception to that. It's an excited utterance. It's a statement made for medical diagnosis. It was recorded. It was a business record, on and on. So that's just a little introduction. You might take some time and look at this. Rules of civil procedure at the Texas level would be like similar to federal rules, right? It's going to talk about the rules of how you file, when you file, what your discovery is, and anything you may have to take in the process. So instead of me going through this, I want you to take a few minutes and look through these rules and become familiar with them. And this is just part of our legal process. And I understand the word process has two meanings. One is to serve process, but the other is just how we use process as synonymous as procedure. Thank you. We'll get ready for video 2. Thanks for your time and attention.